About me, so as Sarah mentioned, I'm the director of the National Sea Grant Law Center. We're based at the University of Mississippi School of Law. I am an attorney. I'm an environmental attorney by training. I went to Vermont Law School to get both a JD and a master's in environmental law. So my background is approaching it from that kind of pollution framework. And so my center is set up to provide non-advocacy, legal, research, education, and outreach services to the Sea Grant programs around the country. So we're a bit of generalists, and so I've been following this a little bit, the issues as the various Sea Grant programs have worked on it. And the regulation of contaminants in the environment is a very complicated area of law because of the variety of pollutant sources, the different contaminants that we're looking at, policy tensions, differing assessments of risk, and knowledge gaps. So my goal today is not to try to provide a detailed legal analysis. There is definitely not enough time for that, and also I'm sure your eyes would be glazing over by the time that I got through with that, but rather to highlight some of the major challenges in dealing with our current legal structure that I think is relevant to the topics and the conversations today. So the first thing I wanted to start with is terminology. First, there's no legal definition of emerging contaminant or contaminant of emerging concern, whatever phrase that you're used to using. When I actually conducted a search of state and federal law in preparation for today's presentation, I found only 3 states that even mention emerging contaminant. California has it in a regulation dealing with drinking water grants, so grant funding. Minnesota mentions it in a provision for the accreditation of labs, and then Ohio has it in a drinking water regulation. So they're not using it in a way that is defining it or attempting to regulate emerging contaminants as a general category. So scientists or researchers tend to divide contaminants into a lot of different categories. There's natural, man-made, legacy, emerging. And there are contaminants, of course, that we've known about for a long time, DDT, lead, PCBs. When I've seen those are usually referred to as the legacy contaminants. Usually legacy contaminants are banned from use by law or sale or very tightly regulated. But of course, they can persist in the environment and continue to cause problems. Other contaminants have been in use for a long time, but maybe the concerns over human or environmental health have emerged more recently. So examples of these may be pharmaceutical byproducts or the residues of pharmaceuticals in the water, or plastics with the BPA. And so those I've seen kind of categorized of those contaminants of emerging concern, so they've been around. And then there's new products that may have unknown effects like nanoparticles, and in some literature refers to them as emerging contaminants. So we have a whole range of terminology, and I noticed this morning there was also different ones than just those. For the purposes of my presentation, those distinctions don't matter because it's not a legal term of art. There are no laws really dealing with emerging contaminants, so what we call them doesn't really matter from an attorney's point of view right now. There's usually a difference between the legacy contaminants, and so when I think of a contaminant of emerging concern or emerging contaminant, in my mind, that's something that's not regulated yet. So it's not currently regulated. It hasn't been deemed or identified under law as posing a public health or environmental risk. So you've got the legacy contaminants that are being regulated, and then we have all of these other contaminants that we might be worried about, but we haven't taken any action on them yet. So there's a number of challenges in addressing emerging contaminants within our current framework. First, and it's really important to note this, as I mentioned, there's no overarching federal or state legal framework or legal regime for emerging contaminants. What we have is a patchwork of laws, regulations, programs, advisories that can be brought into play that are designed to deal with drinking water safety, water pollution, and consumer product safety. And contaminants are dealt with differently under each of these regimes, and I'll walk through that in the rest of the presentation. But you have maximum contaminant levels for drinking water, water quality standards, and water quality criteria for pollutants for water pollution, and then FDA standards for consumer protection. And there are major challenges in trying to address an emerging contaminant under these regimes. First, if any of you have been involved in any of the regulatory processes, it can take years, if not decades, to get federal action on a particular contaminant, to actually have the EPA take action and list a contaminant under one of these programs. Second, although states have the authority to act, and often do when the federal government is not acting, those standards are not always consistent, and that can increase regulatory burdens on the regulated community, especially if you're dealing with consumer products, but it also just generates confusion anytime things are different across state lines. So what I wanted to do with the presentation is kind of take a bit of a whirlwind tour through these different regimes and talk a little bit about how they might come into play with an emerging contaminant. So under the Safe Drinking Water Act, the EPA is authorized to set national standards for drinking water to protect against health effects from exposure to naturally occurring and also man-made contaminants. Now, the standards established by the EPA under the Safe Drinking Water Act are only applicable to public water systems. And these are systems that have more than 15 connections or are serving at least 25 people for 60 days a year. And public water systems must ensure that the water they provide meets health standards established by the EPA, and they must also test the water according to EPA regulations. And I mentioned the definition of public water systems because private wells are not covered and therefore not protected by the Safe Drinking Water Act. So if there are contaminants in groundwater that are being used for a private well, there's nothing under the Safe Drinking Water Act that can come into play to protect the health of the residents of that home or maybe a small system. And about 10% of people in the United States rely on private wells for drinking water. So it's not a lot, but it's still big enough to be concerned about. So under the Safe Drinking Water Act, the EPA is required to establish maximum contaminant level goals and then set maximum contaminant levels for contaminants that may have an adverse effect on human health, are known or substantially likely to occur at a frequency and at levels of public health concern. So they're occurring at a level that would raise a public health concern. And where regulation presents a meaningful opportunity to reduce those human health risks. And maximum contaminant level goals, the goals are aspirational. They need to be set at a level at which no known or anticipated adverse effect on the health of the person occurs and allows for an adequate margin of safety. So one example of this is lead. The maximum contaminant level goal for lead is 0 because there's no safe known exposure level for lead. But the EPA's maximum contaminant level, also referred to as action level, for lead is 15 parts per billion. So the goal is we don't want any lead in our water, but it's really not attainable, so that we have a maximum contaminant level of 15 parts per billion. And that action level is triggered if more than 10% of the tap water samples are above that action level. So it's important to note that these action levels are not health-based standards, or at least the one for lead isn't. Lead, the 15 parts per billion is a performance-based standard. This was a standard that the EPA believed that public water systems could achieve given the amount of lead plumbing in our distribution systems and the use of corrosion control to prevent the lead from leaching from the pipes. But it was not set as a health-based standard. And while it's not an emerging contaminant, we've known about lead and the dangers of lead since Roman times. I think it's important to kind of talk about lead and what happened in Flint, Michigan, because it illustrates the challenges with the existing system. So the question became, in Flint, Michigan, how did the water supply of a major US city become contaminated with lead? And Flint, Michigan is really an example of a failure on every level to protect human health. There were legal failures, institutional failures, political failures. Really, the major problem in Flint was the decision not to institute corrosion control right away when they switched water from the Detroit system to the Flint River. And they would kind of take it, wait and see, right? We'll see what happens, maybe we'll be okay, rather than just doing corrosion control right away. The other thing, and it's a little hard to see on the slides, the other issue with the Safe Drinking Water Act, not just with lead, but other contaminants, is sampling and the way that sampling is conducted. So under the EPA's lead and copper rules, samples are supposed to be collected from sites that are more likely to have lead in the plumbing and in the distribution system. And so you want to look where you think you have the greatest risk of lead. However, there are allegations that the Flint water system did not kind of meet these criteria for sampling, that they were actually sampling in areas that didn't have a lot of lead plumbing, and therefore you're not going to get higher lead readings because you don't have the risk. And the illustration on the slide shows the difference. The one on the right is the sampling conducted by the city. The image on the left is the sampling done by the Flint Water Study Group out of the University of Virginia, where they went more of a scientific, take the same amount of samples from all the different districts, and they got a much different reading with respect to lead contamination in the city than the city's water supply actually did. So the way that you can do the sampling under the Safe Drinking Water Act can affect the results. And then there were also just general questions about the way the EPA and the State Department of Environmental Quality kind of exercise their emergency powers and other regulatory actions once they saw that there was a risk and that there was a concern. And so if we have this much trouble with lead, something that has been banned for use in the United States since the 70s, and we have known of the risk for a long time, just encourage you to think about what that means for regulators and policymakers on a truly emerging contaminant that we're not really sure what the risk is or what levels of concentrations it's occurring in the environment. So how would the Safe Drinking Water Act apply to an emerging contaminant? Think about, just pharmaceuticals in general. I've been talking about that a lot this morning. But you'd have to pick one, right? Pharmaceuticals is a big category. They're looking at particular contaminants, so maybe it's antidepressants, maybe it's a particular antibiotic. So to regulate pharmaceuticals under the Safe Drinking Water Act, it is not enough to just show that they're there. So just being able to detect that there's compounds in the drinking water isn't enough for the EPA or a state environmental agency to take action. The EPA or the state agency that's implementing the Safe Drinking Water Act on behalf of the EPA would have to find that the drug or the compound in question may have an adverse effect on human health, is known or substantially likely to occur at levels and concentrations that would pose a public health risk, and that regulation would actually help mitigate that public health risk. And so we haven't talked yet. A lot of the presentations today have been about detection, not so much about the impact. So what changes in the environment are we seeing? What is the human health risk? I think about like for caffeine or sucralose, like what impact is that really having if you drink water that have those compounds in it? So is the science there to support a maximum contaminant level goal or a maximum contaminant level for a particular compound? Do we know what the health effects are of long-term exposure to low levels of an antidepressant, for instance, in the drinking water? This is a very high bar for the EPA to meet, and there actually haven't been that many contaminants added to the list in the decades since the Safe Drinking Water Act. It's a lot of documentation that the EPA needs to do, and given the current kind of anti-regulatory environment in DC especially, it's going to be, I think, even harder for the EPA to take action. But let's assume that there is the science there to support setting a maximum contaminant level for a particular pharmaceutical compound. Well, can the water treatment system remove that compound from the source water? Is that technically feasible? Is that something they could do in order to meet that maximum contaminant level? And we already see some of this challenge happening with nitrates. That is a concern. There are limits for how much nitrate can be in drinking water, and in areas with a lot of agricultural runoff, it is difficult sometimes for drinking water systems to get the levels of nitrates in the drinking source water to the level that they need. And so that's costing money to upgrade the facilities and kind of putting the burden on the treatment systems. So the larger policy question that's there is, should this be a water treatment issue? So make the drinking water systems take it out of the water before it gets to your house? Or is it a pollution problem that we need to keep it out of the environment first? And so that may be the better approach, right? If we keep it out of the water, then we don't have to worry about it being in the drinking water. And so the law designed for that is the Clean Water Act. So the second mechanism that I wanted to talk about. So the overall goal of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. The Clean Water Act prohibits the discharge of any pollutant unless the discharge is authorized by a National Pollutant Discharge Elimination System permit. So these are the NPDES permits. They're only applicable to point sources. So the image on the right with the pipes, you need to have a point source, you need to have a pipe or some other discrete conveyance. Agricultural runoff is generally exempt from regulation under the Clean Water Act. And unless you're a very large agricultural livestock production operation, they do need permits. But most runoff from fields is exempt. So the Clean Water Act isn't going to get at the agricultural sources. States are required to establish water quality standards for waters within their borders by designating specific uses. Examples of designated uses include recreation, drinking water, irrigation. States also have to establish criteria by which to protect those uses, control the source of the pollutant, and then monitor and assess the water quality. So the EPA is required by the Clean Water Act to develop and publish ambient water quality criteria to guide and assist the states in the development of their state-specific water quality standards. They can use those federal guidelines to help when they're working through what they want their criteria to be on the state level. The EPA has issued water quality criteria for a number of heavy metals, pesticides, chemical compounds. So, there's criteria for atrazine, malathion, tributyl tin. So there's a long list of things that EPA has taken action on. But these criteria are not zero most of the time. There's usually some tolerance for the compound to be found in the environment because, again, what they're doing is they're trying to establish what level of the compound can be present in the environment before it causes harm to the environment. And then it's when it goes over that level that you need to take action. So if a state sets their water quality, they have their designated uses, they use the water quality criteria to determine whether or not the water body is meeting that designated use. If it is not meeting the designated use, so for instance, if it's designated for fishing, but it's not safe to eat the fish from the water because they're contaminated with mercury or DDT, then it's considered impaired. and the state has to list the water body as impaired and develop a total maximum daily load, which is a fancy word for like a pollution budget. You just have to decide how much mercury can come into that water body before it no longer meets the designated use. And there are TMDLs for lots of different contaminants, for nutrients, so for nitrogen, phosphorus, mercury, DDT. There's even a trash TDML. California has one for the LA River that's just trash, so it kind of gets a little bit at plastics. And so once you develop a TMDL, then all those discharges that are coming into that water body, the point source discharges from wastewater treatment facilities, from industries, as well as non-point sources from runoff and stormwater, have to be reduced, in theory, under the law, have to be reduced below that level. You have to stay within your pollution budget. So coming back to the pharmaceutical exercise, so a lot to think about here with respect to the Clean Water Act. First is, how are the pharmaceutical compounds getting into the water? I mean, are they, some are byproducts of proper use, so the body isn't metabolizing all of the compounds. Some is overuse, both by humans, but then we also know in the agricultural sector, there may just be overuse of antibiotics that's resulting in that getting into the environment, and improper disposal, so just flushing them down the toilet. So there's a lot of different ways that they're getting into the water. And so to address pharmaceuticals under the Clean Water Act, state would have to develop water quality criteria for the drug compound in question. If the water wasn't meeting that criteria, it would be considered impaired, and the state would have to develop a total maximum daily load. And that would require identifying all the various sources, both point and non-point sources, for the drug. And then the question would be, well, how do you start reducing that pollutant loading, that loading of that compound? Water treatment plants, so the sewage treatment plants, the wastewater facilities, they do have permits under the Clean Water Act, so there's regulatory authority there to try to get them to reduce their discharges. But that gets back to the question about, do they have the technology to do that? Is it feasible? Can they afford the upgrades to the plant? Some of the laws and ordinances that states have, which I think is part of the topics for this afternoon's conversations, that require the proper disposal of drugs or encourage take-back programs, can help a little bit to reduce the inputs into the wastewater stream. But those, the Clean Water Act doesn't regulate us and what we kind of flush down the toilet. It's regulating what the wastewater treatment facilities are discharging. And again, is there science there to support the development of the criteria? And is it feasible to achieve whatever the goals are that we're trying to move towards? And then I just wanted to briefly touch on consumer product safety, because it's another one that's out there that could be used. Consumer Product Safety Act authorizes the Food and Drug Administration to develop standards and bans for consumer products. So the Consumer Product Safety Commission is the agency or the office within the FDA that's responsible for implementing the law. They have lots of standards out there for a lot of different contaminants. Flame retardants, there are standards for that for use in furniture. Children's products, and some furniture can't contain certain concentrations of lead. 6 types of phthalates I'll always say it wrong. Phthalates are banned in clothing and furniture and toys for children. So there's a lot of different standards. So as new products come onto the market, the Consumer Product Safety Commission works to assess the risk of chemical exposures and other safety threats. So it's another one that's out there that can be used. So Consumer Product Safety Commission could take action if a contaminant in a consumer product poses a risk to human health and safety. Now this regime, is not going to be as applicable to pharmaceuticals as it might for other products, because we're using the drugs. We need the drugs to treat disease, and they are being sold and they're operating as they should, according to the FDA and the medical community. So you're not really going to see a consumer ban, most likely, on a drug. But it may work for other type of consumer products, like personal care products. You could certainly see something if there's a health risk with that. But if the concern is the impact on the environment, it's not going to fall within the jurisdiction of the Consumer Product Safety Commission, because they're concerned about human health and human health impacts. That said, products can be completely banned. So Congress can take action to completely ban a particular product for whatever reason they would want to. And the most recent example of this is late in 2015, when Congress prohibited the manufacture and sale of rinse-off cosmetics that contained plastic microbeads, with the passage of the Microbead Free Waters Act. And so they defined microbeads as small plastic particles, less than 5 millimeters in size. The manufacturers of those products must cease by July of 2017, so almost next month, and sales must stop by July of 2018. And then manufacture of non-prescription drug products containing microbeads must end by July 2018 and sale by July 2019. So that's just a very classic product ban. The act also expressly preempts state law. So you had several years ago a couple different states starting to take action on microbeads, and they all were a little different, and it was causing confusion. And so Congress passed the federal law and then preempted the state law, which to try to address that confusion and make it consistent across the country. And I just saw too, I think it was this week, Maryland became the second state to ban the routine use of antibiotics in livestock and poultry operations. So the first state was California. So I think we'll see a similar kind of movement with that, with states taking action, and that may then lead to more pressure for the federal government to take action to kind of streamline what those states are doing and eliminate any confusion. And so what I wanted to kind of end with was a little bit of a challenge for the group. I don't know, I might be the only attorney here. I'm used to being the only attorney in the room in Sea Grant meetings, but to challenge the group to think about what the proper role to play in the whole conversation. I think it's important to remember that there are policy trade-offs with every decision that we make with respect to law and regulation. We have to consider what the risk of harm is if we stop doing or selling whatever product that we're concerned about. So if we stop selling sunscreen or using sunscreen, what the risk of that is. So there are just things that have to be considered. Lead is a classic example of this. We banned lead from gasoline because we were concerned about the human health impacts of lead. They replaced it with MPTE, which became a huge problem with groundwater contamination and is now its own human health concern and has also been banned. So I always think there's unintended consequences, but there's also sort of push and pull on the policy level about what we're doing and what we're focusing on, and it just brings back that the EPA has a lot of challenges in getting the evidence they need to be able to meet these high burdens under federal law. And it's partly because the United States does not follow the precautionary principle. So most of our chemicals in our products are innocent until we prove them guilty. Not guilty until we prove them innocent. So you have to have the kind of science there to prove that they're causing harm versus what may be a preferable approach, which we would say, well, we're going to assume that they're causing harm until you establish otherwise. And so it's kind of a backwards way to think about it. But there's lots of different things that I think that folks in this room can contribute with. One is providing the scientific information that might help with raising awareness of the health and the environmental threats. encouraging and assisting, obviously, with the development of standards. What would be a good water quality criteria for pharmaceuticals? There are certain ones, antibiotics. I think there's a lot of information out there about the risk of antibiotics and antibiotic-resistant bacteria. Also, the endocrine disruptors and the impact that they're having on aquatic ecosystems. And so how can we get that information kind of worked into state and federal law? And then sharing information from lessons learned. So if you've been involved, like it'll be really interesting to see how the situation changes in Maryland and how that law is implemented and whether there are lessons that can be learned in other places from those kind of different approaches that the state agencies are taking. My contact information, I'll be around for the rest of the conference and happy to talk and look forward to hearing the rest of the presentations today.